Good morning, my lord.
Good morning.
My lord, I'm so sorry for keeping you. I'm so sorry for keeping the court waiting. I sincerely apologize. I was
problem.
about 5 minutes ago about this morning's fixture. It's not a, I sincerely apologize, my lord.
Okay. I'm very sorry too, because I had challenge this morning in starting the proceedings. So, how many counsel are present?
I'll try and see if I can contact
Mr. Reggie.
Yes, ma'am. Yes, sir. We're cancelled to interswitch.
Yes, Mr. Kombwe. What of Mr. Kombwe? Were you able to reach him? Mr. Rejo, unmute yourself.
I'm sorry, my lord, because I've just been informed. Yes. I've just forwarded the message the registrar sent to me to cancel to, to opposing counsel.
Yes. He was actually served. There is confirmation that they were served. So what do we do?
If my lord will be magnanimous enough to give me just 5 minutes, I can reach him on the phone.
Problem. No problem.
Thank you, my lord.
No problem. Yeah. Hello, Fatai. Okay, so we'll give them some time. Okay. 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 So we'll just start and not with no disconnection again. Okay. 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 Thank you. Okay. 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 Thank you. I appreciate it. Thank you. I should be telling you sorry. Thank you. Thank you. I appreciate you. Thank you. Yeah.
Well, it appears Daphne Ikpe from the law firm representing Christopher Isume is present. She's just joined.
Okay, she just joined.
Yes.
May please the court.
Hold on, so we can take appearances.
Okay, my lord.
Yes. Is any of the parties present?
My lord, it appears none of the parties are present.
Okay. Appearances, please.
My lord,
unmute yourself. The other counsel is muted. Mrs. Ekpe is muted. Yes, go ahead and announce your appearance, Mr. Reggie.
With profound respect to my noble lord, I.O. Reju. Yes. My lord, Reju is spelled R-E-J-U. My lord, my humble appearance is for claimant, Interswitch Limited. I'm much obliged.
Appearance for the respondent.
May it please the Honorable Court, D.M. Ekpe. I announce my appearance for the respondent, Christopher Isume.
This ruling should have been delivered on 26th of April, 2021, but for the strike by the Judiciary Staff Union of Nigeria, it is being delivered now due to the uncertainty of our resumption. But thankfully, yesterday, we were notified that the strike has been called off. So nevertheless, the notices have gone out before the communication came. By motion on notice, dated and filed on 6th August 2020, brought pursuant to sections 4, subsection 1 and 2 and 5 of the Arbitration and Conciliation Act, Cap A 18, Laws of the Federation 2004, and Order 17, Rule 1 of the National Industrial Court of Nigeria Civil Procedural Rules 2017, hereinafter referred to as the rules, and under the inherent jurisdiction of the court, the defendant applicant, hereinafter referred to as the applicant, pray the court for and order staying for proceedings in this suit on the claims relating to dividends, that is, claims 2 and 4, set out in the claimant's general form of complaint and statement of facts dated 2nd July 2020, pending arbitration, pursuant to the terms of the shares allocation letter dated 11th February 2014, and an accompanying document in this Schedule 1 titled, and I quote, "The Scheme Rules for the Interswitch Limited Employee Equity Benefit Trust Scheme," end of quote, dated 27 January 2014. Such order or further orders as the Honorable Court may deem fit to make in the circumstance. Upon the ground that by virtue of the Employee Equity Benefit Trust Scheme, and pursuant to an allocation letter dated 11th February 2014, and an accompanying document in this Schedule 1 titled "The Scheme Rules for the Interswitch Limited Employee Equity Benefit Trust Scheme," dated 27 January 2014, hereinafter referred to as the 2014 Scheme Rules, parties agree to refer all disputes arising from the subject of the scheme, including dividends accruing therefrom, to arbitration. The application is supported with 19 paragraphs of affidavit deposed to by the applicant, to which he attached 6 exhibits, marked exhibits D1 to D6. In compliance with the rules, the applicant filed a written address dated 6th August 2020. In opposition to the application, the claimant responded, hereinafter called the respondent, filed 13 paragraphs counter affidavit dated 3rd December 2020, sworn to by Mr. Ibitayo Reju, legal practitioner and the respondent solicitor's chambers. Attached to the counter affidavit is one exhibit, the amended offer of appointment and a written address dated 30th November 2020. The applicant filed a reply on points of law dated 29 January 2021. Arguing the application on 15th March 2021, Mr. Nweneka, counsel for the applicant, relied on the affidavit in support of the motion, the attached exhibits, and adopted the written address and reply on points of law in urging the court to grant the application. He submitted that the application is not a challenge to the jurisdiction of the court. In his response, Mr. Reju, learned counsel for the respondent, relied on the counter affidavit, the attached exhibit, and adopted his written address as his argument in opposition to the application. Learned counsel referred the court to the originating process, particularly paragraph 40 of the statement of facts, and submitted that the only process which the court will examine in consideration of this application is the statement of facts, and the documents relied on by the applicant is not one of the documents. The document relied on by the applicant is not one of the documents front-loaded by the respondent. He argued that the applicant has taken steps in the matter and urged the court to dismiss the application. Responding, Mr. Kongbe maintained that the applicant has not taken steps in the matter and undertook to supply authorities on what amounts to taking steps in a matter, which he did by later dated 17th March 2021. The facts justifying this application are set out in the applicant's affidavit in support, are that the applicant, while in the employment of the respondent, was allotted 52,044 shares of the respondent, out of which he has disposed of 9,058 shares, leaving 42,982 shares. Subsequent to his resignation, the respondent notified him of his decision to declare him a bad leaver, which will result in his forfeiture of accrued entitlements and the beneficial interest in the shares. Relying on paragraph 16.2 to paragraph 16.4 of the scheme rules for the InterSwitch Limited Employee Equity Benefit Trust Scheme, hereinafter called the 2014 Scheme Rules, it commenced arbitration proceedings. The arbitral tribunal was constituted and parties submitted to the jurisdiction of the tribunal and paid the first tranche of the arbitrator's fees. Pursuant to the order for directions number 1, the applicant filed a statement of claim, and the respondents reliefs 1, reliefs 2, and 4 deal with the subject of reference in the ongoing arbitration. The applicant reiterated his willingness to participate in the arbitration process and that he has not taken any steps in these proceedings. And it will be in the interest of justice to stay proceedings with respect to the dispute arising from the accrued dividends. The letter of offer and scheme rules were attached as Exhibit D1. The notice of arbitration, appointment of sole arbitrator, the arbitrator's acceptance of his appointment, order for directions number 1, and the applicant's statement of claim are Exhibit D2, D3, D4, D5, D, and D6 respectively. The respondent did not deny that their parties have commenced arbitration. His case is that the applicant executed an amended contract of employment wherein he undertook not to be involved in any capacity with any business in competition with his business for a period of 1 year after termination of his employment, which undertaking he has breached by taking up employment with Visa West Africa. And the reliefs he seeks in this suit arose from the applicant's breach of a fundamental clause in the amended contract of employment, and he did not plead the Equity Benefit Trust Scheme of 2014. The amended contract of employment is marked Exhibit A1. The applicant submitted one issue for determination in his written address in support of the application, to wit, whether this honorable court ought not to stay further proceedings in this suit as it relates to the claims on dividends, which will come under the subject matter of the pending arbitration. He submitted that this suit, as constituted, touches on the dividends accruing from the Equity Benefit Trust Scheme regulated by the scheme rules for the InterSwitch Limited Employee Equity Benefit Trust Scheme, and by agreement of the parties, disputes arising from the scheme are to be resolved by arbitration. And being a party-driven process, the court has a duty to uphold the terms of an arbitration agreement on the authority of Kano State Urban Development Board and Fast Construction Company Limited, and MV Lupex and NOC and S Limited, citation supply, amongst other cases. Relying on exhibits D5 and D6, he argued that arbitration proceedings have commenced, and by Section 5 of the Arbitration and Conciliation Act, the court has a discretion to stay proceedings, which discretion must be exercised judicially and judiciously in accordance with rules of law and justice. It was further submitted that parties must have agreed to settle the issue by arbitration, before the court can make an order for stay of proceedings, noting that the applicant has not taken any step in the proceedings before making this application and is ready and willing to participate in the arbitration process. Reliance was placed on Bekoye and Lotus Capital Limited as cited. The court was ordered to grant the application. The respondent formulated one issue for determination in his written address, that is to say, whether the defendant is entitled to the relief sought in this application. It was submitted for the respondent that in determining jurisdiction, the court is enjoined to consider only the statement of facts, which determines the dispute between parties on the authority of Olofu and Itido, as cited. Then a counsel argued that the dispute between the parties arose from the employment contract, and the reliefs are premised on breach of the amended contract of employment, Exhibit A1, noting that there is no provision in the documents pleaded by the respondent relating to arbitration. Further argued that there is no agreement between the parties to refer dispute can only apply to disputes arising from the 2014 scheme rules, which is not the case here. Resultantly, he argued that the cause of action in this suit is different from the cause of action in the arbitral proceeding, and the court cannot delve into the merits of the claim at the interlocutory stage, maintaining that if the court declines jurisdiction on reliefs 2 and 4, it would have pronounced on the merits of the case before hearing evidence. Reliance was placed on the case of Adetono and another Zenith Bank PLC. The court was ordered to dismiss the application. By way of reply on points of law, any counsel for the applicant argued that this application is not a challenge to the jurisdiction of the court, and to that extent, the respondent's arguments and cases cited in support thereof, which show that the only documents the court is to consider are the complaint and the statement of facts are inapplicable. Reference was made to Section 5.2 of the Arbitration and Conciliation Act and MB Panama's Bay and Holland PLC as cited. He explained that the responsibility of the applicant to bring an arbitration agreement to the attention of the court, and the court's duty in that regard have been given judicial stamp in Iwanyanwu and Minister of Agriculture and Water Resources and another citation supplied, and argued that the determination of this application will not amount to deciding the substantive suit before hearing evidence, but a determination of the parties' right to have the matter determined in line with the arbitration agreement, noting that the attitude of the court is to determine the application for stay of proceedings pending arbitration and uphold the agreement of the parties to settle their disputes through arbitration. The case of Nissan Motor Corporation Company Limited and Nissan Nigeria Limited and others was cited in support. In his letter of 17th March 2021, Learned Counsel for the applicant noted that what the law disallows is where one takes other steps before filing or without filing a motion for stay of proceedings, and refer to the cases of Eaglewood Integrated Resources Limited and Olins Investments Holdings Limited and Kano State Urban Development Board and Fast Construction Company Limited, page 227. A summary of the decisions in these cases is that a party who makes any application whatsoever to the court takes steps in the proceedings and acts done in furtherance of the prosecution of the defense amount to taking steps in the proceedings. There is no rejoinder from the respondent. The issue for determination in this application is whether the court should grant a stay of proceedings pending arbitration pursuant to clause 16.2 of Exhibit D1. The application is predicated on sections 4 and 5 of the Arbitration and Conciliation Act and argued on one ground, which have been set out earlier in this ruling. The applicant maintains that on the basis of reliefs 2 and 4, the court ought to stay proceedings pending arbitration, which has commenced. The respondent thinks otherwise, arguing that his case is built on applicant's breach of the amended offer of appointment dated 1st April 2018 and not on the scheme rules of 2014. Undoubtedly, an arbitration agreement in a contract is a distinct agreement. See Stabilini, Visioni Limited, and Mallison and Partners Limited, citation supplied. There are two classes of arbitration clauses. The first class is where the provision for arbitration is a mere matter of procedure for ascertaining the rights of the parties and does not exclude the right of parties to sue on the contract itself, but leaves the other party with an option to apply for stay of proceedings. The second class is where arbitration, followed by an award, is a condition precedent to any other proceedings being taken, not upon the contract, but on the award made pursuant to the arbitration clause. See the cases of Obembe and Wemabod Estates Limited, Federal Ministry of Health and Others and DASCON, Nigeria Limited, and FILAC Concept Limited, and Attorney General of Akwa Ibom State. Citation for these authorities are supplied in the ruling. Arbitration clauses in the first category do not ask the jurisdiction of the court in spite of the use of the word shall in the agreement. Consequently, either party to the agreement may, before its submission to arbitration, commence legal proceedings in respect of the claims covered by the agreement. See Obembe and Wemabod Estates Limited, Supra at page 79, Scout Nigeria PLC and Sterling Bank PLC, and Mainstream Bank Capital Limited, and another, and Nigerian Reinsurance Corporation PLC. Citation supplied. Clause 16.2 of Exhibit D1 provides thus, and I quote, any dispute arising between the parties hereto or involving any of the beneficiaries of the scheme, which cannot be resolved amicably, shall be referred to arbitration in accordance with the Arbitration and Conciliation Act, Cap A, 18, laws of the Federation of Nigeria 2004, or any statutory modification or reenactment of the said law for the time being in force, end of quote. Clearly, the arbitration agreement relates to the respondent's employee equity benefit scheme, trust scheme. It is not applicable to all disputes arising from the contract of employment. It is for this reason that I agree with the submission of learned counsel for the respondent. In paragraph 4.13 of the written address in support of the counter affidavit, that the provision of clause 16.2 of 2014 scheme rules can only apply to disputes arising from the 2014 scheme rules. It is beyond contest that there is no averment in the statement of facts on the scheme rules. However, in both the complaint and the statement of facts, the respondent seeks reliefs which are not founded on the amended offer of appointment Exhibit A1. These are reliefs 2 and 4. And for clarity, it is set out here. I set out the reliefs. These reliefs, together with reliefs 1 and 3, form the substratum of this case. Although the respondent discreetly made no reference to 2014 scheme rules, the relief sought derived from the 2014 scheme rules and make the rules inexorably applicable to this case, I so hope. While it is true, as argued by the respondent, the court is at liberty to have regard to any document bearing on the dispute before it. This conclusion is implicit in Section 5 of the Arbitration and Conciliation Act, which provides, and I quote, if any party to an arbitration agreement commences an action in any court with respect to any matter which is the subject of an arbitration agreement, any party to the arbitration agreement may, at any time after appearance and before delivering any pleadings or taking any steps in the proceedings, apply to the court for stay to stay the proceedings. Subsection 2, a court to which an application is made under subsection 1 of this section may, if it is satisfied, A, that there is no sufficient reason why the matter should not be referred to arbitration in accordance with the arbitration agreement, and 2, that the applicant was at the time the action was commenced and still remains ready and willing to do all things necessary to the proper conduct of the arbitration, make an order staying the proceedings. The operative phrase is, with respect to any matter which is the subject of an arbitration agreement. The question that may be asked is, are release 2 and 4 subject to any arbitration agreement? The answer is definitely in the affirmative. Consequently, notwithstanding the fact that the respondent did not plead the 2014 scheme rules, the 2014 scheme rules are applicable by reason of reliefs 2 and 4, and the dispute being one subject to an arbitration agreement ought to abide the decision of the sole arbitrator. See Mainstream Bank Capital Limited and another, and Nigerian Reinsurance Corporation PLC, and Philip Concept Limited, and Attorney General of Akwa Ibom State Supra. This does not in any way mean that the court has decided release 2 and 4 before hearing evidence. That is not the end of the matter. The respondent contends the applicant has taken steps in this matter. The applicant maintains that he has not taken steps and relies on the cases of Eaglewood Integrated Resources Limited and Orleans Investment Limited, Holdings Limited, and Kano State Urban Development Board and Fast Construction Company Limited, Supra, to the effect that a party is said to have taken steps in the proceedings where he makes any application whatsoever to the court or takes steps in furtherance of the prosecution of the defense. A starting point in this consideration is Section 5, Subsection 1 of the Arbitration and Conciliation Act, which states that if any party to an arbitration agreement commences any action in any court with respect to any matter which is the subject of an arbitration agreement, any party to the arbitration agreement may, at any time after appearance and before delivering any pleadings or taking any steps in the proceedings, apply to the court to stay the proceedings. The two conditions to be satisfied by the applicant in this subsection are that he has not delivered any pleadings or taken any other steps in the proceedings. In Obembe and Wemabod Estates Limited, 1977, Law Pavilion Electronic Law Reports, 2161, Supreme Court, pages 19 to 20. The Supreme Court held that, and I quote, a party who makes any application whatsoever to the court, even though it be merely an application for extension of time, takes a step in the proceedings. Delivery of a statement of defense is also a step in the proceedings. This decision was cited with approval in Mainstream Bank Capital Limited and another, and Nigerian Reinsurance Corporation PLC, Supra. At page 445 of the report, Kekrepun JSC remarked that, and I quote, where a party takes steps in the proceedings beyond applying for a stay of proceedings, he will be deemed to have waived his right to insist on recourse to arbitration, end of quote. In the instant case, the motion for stay of proceedings pending arbitration was filed on 6 August 2020. The motion on notice dated 20th August 2020 for extension of time to file and serve its memorandum of conditional appearance, statement of defense and counterclaim, and accompanying documents, later dated 5th August 2020 for calculation of default fees, and I quote, to regularize the defendant's conditional memorandum of appearance and statement of defense, end of quote. The memorandum of conditional appearance and statement why these processes amount to taking steps in the proceedings in the light of the decisions in the Obembe and Wema Board Estates Limited and Mainstream Bank Capital Limited and another, and Nigerian Reinsurance Corporation PLC. The argument of any counsel for the applicant is that they were filed after the filing. The argument of any counsel for the applicant, as I see it, is that they were filed after the filing of the motion for stay of proceedings. This appears to be a strained interpretation of Section 5, Subsection 1 of the Arbitration and Conciliation Act. And this occurs with the definition of before in the Longman Dictionary of Contemporary English, new edition, for advanced learners, which defines before as earlier than a particular event or action, earlier than something or someone. In this regard, though the processes amount to taking steps, they were filed after the application for stay. But can it be said that the applicant has not taken steps? I do not think so. The decisions in Obembe and Wema Board Estates Limited and Mainstream Bank Capital Limited and another, and Nigerian Reinsurance Corporation PLC, all go to show that any application made in furtherance of the proceeding is deemed to have been taking steps. And in this case, the applicant filed a motion. In this case, the applicant filed a motion for extension of time and has gone ahead to file an application for calculation of default fees and also filed the defense processes and counterclaim. Regard being had to the state of authorities, it can rightly be said that the applicant has taken steps in this proceeding. It should be noted that a grant of an application for stay of proceedings pending arbitration is not automatic. It is discretionary, and this is evident in the use of the word may in Section 5, Subsection 2 of the Arbitration and Conciliation Act. See FELAC Concept Limited and Attorney General of Akwa Ibom State at page 456, paragraphs E to F. From Section 5 of the Arbitration and Conciliation Act, an applicant for stay of proceedings pending arbitration must condescend on particulars and justify the exercise of the discretion in his favor. CMV Panama's Bay and Olam Nigeria PLC and Nigeria LNG Limited and Africa Development Insurance Corporation Company Limited. Citation supplied. The applicant must satisfy the court that he has not taken any steps in the matter. There is no sufficient reason the matter should not be referred to arbitration in accordance with the arbitration agreement, and he was at the time the action was commenced and still remains ready and willing to do all things necessary to the proper conduct of the arbitration. These conditions are conjunctive and must be proved by affidavit evidence to the satisfaction of the court to warrant the grant of a stay. While there is evidence that the applicant was at the time the action was commenced and still remains ready and willing to do all things necessary to the proper conduct of the arbitration, and there is no sufficient reason the matter should not be referred to arbitration in accordance with the arbitration agreement, I hold that the applicant has taken steps in the proceedings and thus deemed to have waived his right to insist on recourse to arbitration. Resultantly, the applicant has not satisfied the conditions specified in Section 5 of the arbitration. I don't know if counsel is still present.
I'm so sorry, my lord. I sincerely apologize. We lost you for a bit. I think the network. So the conclusive part of your ruling.
At what point did you lose me?
I think it was when you said, when you referred to the fact that, can we say that the applicant must satisfy all the conditions for the grant of an application for stay of proceedings. And from then on.
And you didn't draw my attention to it. Wow. So basically the summary, let me read the conclusion. The conclusion is, in the circumstance, the motion on notice dated 6th August 2020 fails, and it is hereby dismissed. I make no order as to cost. Ruling is entered accordingly.
As the court pleases.
As the court pleases.
As the court pleases.
Can we take a date for further proceedings?
I'm so sorry, my lord.
Yes.
I'm so sorry. Before I proceed to thank my lordship for the well-considered ruling, my learned colleague, who is my senior, Michael Akine, joined the call whilst my lordship was delivering the ruling. I do not know if my lordship will be magnanimous enough to take his appearance.
That's Mr. Rejo.
Yes, sir. Counsel to the claimant, Michael Akine.
My lord.
Hold on.
My lord. Okay.
So Michael Akileye and Ibita Orejo, I.O. Rejo for the claimant. And my lord, we do sincerely thank my lordship for the well-considered ruling. Since my lordship assumed this noble position, some of us had concluded that indeed our labor law jurisprudence is in safe hands going forward. We're much obliged, my lord. I'm much obliged.
You're welcome. You're welcome. Can we take a date?
My lord, in the same vein, my senior colleague just joined. He joined while your lordship was giving the ruling. My lord, please, can you take his appearance to Ayodele Adeyemo with Daphne Ekpe appearing for the defendant?
What are their names?
Ayodele Adeyemo appears with myself, Daphne Ekpe, for the defendant.
Yes, so what date and what are we adjourning for?
My lord, since the...
Go and bring my laptop.
Since the coast is clear, my lord, I believe there are no pending applications.
There is.
It's only appropriate that we take a trial date or trial dates.
No,
subject to
they have filed a defense and counter claim, and I don't know if the claimant would want to file a reply and defense to the counter claim. So we'll adjourn for further mention.
My lord, I was going to have a date for
I didn't hear you.
My Lord, I said in the circumstance, I was wondering whether it is possible to have a day for trial, so that on the next adjourned day, we regularize any test they might have filed, and we can put trial.
Okay, I have a trial for 5th of July. Is Monday, 5th of July convenient for you? Council, Monday, 5th of July, is it convenient for trial?
It's convenient for us, for the defendant.
Unfortunately, my lord, it's not convenient. It's
not
convenient.
It's not convenient.
It's not convenient, my lord.
What date is convenient? Can you agree what date is convenient for trial?
My lord, I'm very sorry, my lord, to interrupt your lordship. Michael Akileye, my lord.
Yes, go on.
Your lordship has noted that the defendant now had filed a counterclaim. And
yes,
my lord,
even has a counterclaim.
They will still have to respond to our defense to the counterclaim.
Yes.
My lord, I think that, my lord, it is safer to go with further proceedings. And then, my lord, on the next date, we can then take a day for trial, considering their counterclaim.
So what date for further proceedings?
My lord, I'm sorry, my lord. It is not a system that we can hide in like counterclaim. I mean, to the defense counterclaim. In circumstances, we are very able to defend. So
exactly.
Even if we are to file the reply, we can do that in shortest possible time. Matter has suffered because of this. So, my lord, we are willing to put all the work and get required, get it done, and if we have a day for trial, we'll be ready. So, my lord, we are still asking for a day for trial, subject to complete.
Sorry, my lord, with due respect. Hello?
I know at some point I was asked for I don't want to impose a date. Can we agree on a date for that proceedings? Mr.
As the court pleases. As the court pleases.
My lord, I was making a point before the network went off. I don't know whether my lord can hear me.
Yes, I can hear you.
Yes. So, my lord, the point I was trying to make is that this matter has suffered a lot of delay. We are willing to put in all the energy required to make sure that trial. We are not sure of that thing. We are not certain that we would even need to reply to any defense we file. And even if there is a need to reply to the defense, we put in all energy and we make sure that it's filed. Because we are sure that my lord's docket will be filled up after now. I want to take the opportunity to get a trial. So we put in all the energy and we'll be craving the indulgence of my lord to give us the trial. That's our application, my lord. We are moving.
That's Mr. Adeyemo.
As copy, that's Mr. Adeyemo.
I'm so sorry, my lord.
Mr. Akinleye. Okay, Mr. Reju. Which of you address me? Reju Akinleye.
I'm so sorry, my lord.
Yes.
I have heard the submission or application of my learned friend, and if I may, it may be true that the case has suffered some delay due to no fault of the claimant or the claimant's counsel, my lord. And we just think it will be tidy if my lord adjourns for further proceedings to enable counsel clear the coast. If there are pending applications to regularize, if there are pleadings that are yet to be concluded, if pleadings have not been concluded, I do not think it is proper for us to be discussing getting a trial date. And we're willing to come back at the shortest possible time, perhaps second week in July or first week in July, subject to my lord's my Lord's overriding convenience.
If we are adjourning for further proceedings, I'll give you next week. I'll give you next week, which will be Monday, the 21st of June. So I can argue your application, and whatever parties need to file can be filed, and then we'll proceed to trial. Monday, 21st of June, for further mention.
As the God pleases.
As the God pleases.
That's convenient for us.
As God pleases.
This
You can't hear my Lord.
This case is adjourned to Monday, 21st of June, 2021 for mention.
As the God
As the God pleases.
As God pleases.
Thank you. I appreciate my apologies for the internet disruption. So see you in court on Monday, 21st.
Most grateful, my Lord.
Most
Thank
grateful, my Lord.
Thank you.
My Lord, may we take our leave now?
Yes, you can take your leave. I have other matters.
As God pleases.
I don't know if there's any counsel for EPSOC Paper Mills Limited.
Yes, my Lord. We are both here, my Lord.
Okay, both counsel are here.
Yes, my Lord.
Okay, give me a few minutes so I can print out the ruling.
As the God pleases.
Okay, my Lord.
Let's take appearances.
With profound respect to the Honorable Court, I humbly
Before you
announce my appearance.
Before you announce your appearance, is your client present? Any of the parties present?
Yes, my Lord.
Who is present? Let me take that.
My Lord. No, the 25th claimant is present, my Lord. 25th claimant. Represented by Mr. Benedict Ikegulam, General Secretary.
Yes. Okay. Any other person?
May you please, my Lord.
Who else is present apart from the parties? That's what I want to take first.
Okay.
The defendants are absent.
As God pleases.
Appearances, please.
With profound respect and humility to the Honorable Court, I humbly appear for all the claimants respondents. My Lord, I am Timothy Adewale. Timothy Adewale for all the claimants respondents, my Lord. We are most grateful.
Sorry, let me take your name properly.
I am Timothy.
Okay, Timothy Adewale.
Yes, my Lord. For all
Is that your name?
Yes, my Lord. Timothy Adewale, my Lord.
Okay. I was asking, I lost you at some.
Okay, my Lord.
Am I the only one? I cannot hear my Lord.
Hello.
Hello, my Lord.
Yes. I was taking appearances, please.
Yes, my Lord. Timothy Adewale for all the claimants, my Lord.
Appearance for the defense.
May you please, my Lord, sir?
Yes.
Hello?
Yes.
Yes, my name is
Kola
Wole Rahim. My name is Kola Wole Rahim.
For the defendant.
Yes, my Lord.
Well, this ruling ought to have been delivered on 9th of March 2021, but we could not do so owing to the Judiciary Staff Union of Nigeria strike. Thankfully, the strike has been called off yesterday, but the notice for today's proceeding had gone out before yesterday. That's why we are delivering the ruling today.
As the court please.
By motion on notice, dated 26th November 2020 and filed on 1st December 2020, brought pursuant to Section 254, subsection 1, paragraph K of the 1999 Constitution, as amended, Section 12(1) of the National Industrial Court Act, Order 18, Rules 2, Rule 2, Sub-Rules 3 and 4, and Order 30, Rule 18 of the National Industrial Court of Nigeria Civil Procedure Rules 2017, hereinafter referred to as the rules, and under the inherent jurisdiction of the Honorable Court, the defendants, applicants, hereinafter referred to as the applicants, pray the court for an order that this Honorable Court lacks the requisite competence and jurisdiction to hear and determine the claimant's claim in this suit. An order striking out the suit for lacking in merit. An order of this court striking out the names of the second to fourth defendants for non-disclosure of reasonable cause of action against them. An order of this Honorable Court dismissing the suit in its entirety for being frivolous, speculative, and aimed at harassing the second to the fourth defendants respectively, and for such further order or orders as this Honorable Court may deem fit to make in the circumstances. The application is supported with 6 paragraphs affidavit deposed to by Ms. Yemisi Adewale, a litigation assistant in the firm of the African solicitors.
Water.
In compliance with the rules, the applicants filed a written address dated 26 November 2020 in opposition to the application. The claimants respondents, filed 5 paragraphs counter affidavit dated 21st January 2021, sworn to by Mr. Raphael Akinsoya, litigation officer in the law firm of Adewale and Adewale and Co., solicitors to the respondents and a written address. Arguing the application on 22nd February 2021, Mr. Kolawole Rahim, Senate counsel for applicants, relied on the affidavit in support of the motion on notice and adopted the written address in urging the court to grant the application. Senate counsel abandoned paragraph 4.25 of the written address and by way of adumbration, explained that their submissions have not been controverted. He argued that the second to the fourth applicants are directors, and there is no fact before the court that warrants their joinder. Continuing, he contended that the third applicant is not a director of the first applicant, and urged the court to determine whether there is a reasonable cause of action against the second to the fourth applicants. In his response, Mr. Timothy Adewale, learned counsel for the respondent, relied on the counter affidavit and adopted his written address as his argument in opposition to the application and urged the court to dismiss the application. Elucidating his written address, learned counsel noted that some of the issues raised by the applicants deal with the substance of the suit. A summary of the facts in support of this application is that the respondents are no longer employees of the first applicant, and the second to the fourth applicants are directors and agents of the first applicant, which is a separate legal entity and acted in his best interest. Also, to the knowledge of the respondents, the first applicant is in dire straits arising from the economic recession in the country and on the verge of winding up. Further, the respondents' claim is for gratuity, the payment of which the second to the fourth applicant did not guarantee. And there is no dispute between the parties necessitating this suit. For the respondent, this case is in respect of non-payment of their gratuities, allowances, and other entitlements. And the claim emanated from employment relationship. The second to the fourth applicants are directors of the first applicant and necessary parties to this suit. The applicants raised 3 issues Yes. So I'm on page 3 of the ruling. On issue 1, counsel contended that this court does not have the jurisdiction to adjudicate on the suit, having regards to the provisions of the 1999 Constitution as amended. And the National Industrial Court Act 2006. I'm sorry, I don't know why the thing is echoing. He submitted that in determining the jurisdiction of the court, recourse should be had to the enabling status and the pleading of the claimant. Counsel referred to section 254C, subsection 1, paragraph A and B of the 1999 Constitution as amended, and section 7 and 11 of the National Industrial Court Act 2006, and argued that it is crystal clear from the claimant's pleadings and relief sought that the case relates to non-payment of gratuities and bonuses, which are tagged as a debt, and this court is not vested with jurisdiction to hear matters relating to debts. In urging the court to adopt a literal interpretation of the provisions of section 254C, subsection 1, paragraphs A and B of the 1999 Constitution as amended, and section 7 and 11 of the National Industrial Court Act 2006, he submitted that the words notwithstanding and shall have been judicially defined, relying on the Attorney General of the Federation and Abubakar has cited. He explained that the word notwithstanding, when used in any clause, is a term of exclusion, and that this court can only expound but not expand its jurisdiction. On issue 2, he submits that there is no reasonable cause of action against the second to fourth defendant, and the third applicant is neither a director nor shareholder. Of the first applicant. He also submits that in determining whether a suit discloses a reasonable cause of action, the court looks at the statement of facts on the authority of Julius Berger Nigeria PLC and TRC Bank Limited as cited. And there is nothing placed before the court to show any wrongdoing against them. Relying on order 30 to 18 of the rules of this court, counsel further submits that this court has power to order any pleading to be struck out for non-disclosure of a reasonable cause of action. It was argued that the claimant's pleading falls below the standard of pleading. Standard of pleading wrongdoing, in that there is no wrong committed by the second to fourth applicants to warrant the agenda in this suit on the authority of Obebo and INEC as cited. And the first applicant as a going concern is a distinct legal entity capable of suing and being sued by virtue of section 37 of the Companies and Allied Matters Act. Arguing issue 3, counsel contends that this suit is intended to harass, oppress, and twist the second and third, the second to fourth applicants into paying the respondent the conjured figures claimed as gratuity, noting that the concept of abuse of judicial process is imprecise and involves circumstances of infinite variety. A common feature being improper use of the judicial process by a party in litigation to interfere with due administration of justice. Counsel explained that it is evident from the pleading that the respondents are trying to use the process of the court to harass the applicants to pay their claims, in spite of absence of legally admissible documentary evidence to support the claims. The court was called to strike out the suit. The respondents raised two issues for determination in their written address to wit whether this honorable court lacks the requisite jurisdiction to entertain the claimant's case, whether the second to fourth defendants can be made or joined as parties to this case. Arguing issue 1, Nweneka counsel referred to section 254C, subsection 1, paragraph K of the 1999 Constitution as amended, and submitted that a cursory look at the statement of facts, particularly paragraph 5, will show that this suit. Sorry, I need to check what is causing this vibration. Hello?
Hello, sir.
Are we still together?
Yes, sir.
Okay. Although I can't see anybody now. I don't know. So can I proceed?
Yes, my lord.
Okay. He submits, contrary to the submission of the applicant, that the provision of section 251C, subsection 1, paragraph K of the 1999 Constitution as amended, envisages former employees and all the court to discountenance the submission of the applicant. On the second issue, it was contended that paragraphs 2, 3, 4, 12, and 14 of the statement of facts show that the second to the fourth defendants are necessary parties in whose absence this case cannot be factually determined. Relying on 7-Up Bottling Company and Abiola and Sons, he submitted that in determining cause of action, the court does not need to consider all the averments in the statement of facts. It is sufficient that it looks at a few averments that form the gravamen of the claim. It further submits the cause of action is deemed reasonable once it discloses some questions fit to be decided by the judge on the authority of Thomas and Olufosoye, 1986, One Nigeria Weekly Law Report, Part 18, 669 and 682. It was further submitted that the court cannot, at this stage of proceedings, determine the culpability. Hello?
We can hear you, my lord. We can hear me, Lord.
Okay. That the court cannot, at this stage, determine the culpability of the second to fourth defendants, as this will amount to going into the substance of the case, noting that it may be necessary at some point in the case to lift the veil of incorporation. Relying on Niger Investment and Commercial Enterprises Limited and Alliance International Nigeria Limited, and United Spinners Limited and Charter Bank Nigeria Limited, as cited. Lastly, counsel contended that the fact that a person is an agent does not necessarily prevent his incurring personal liability, and refer to the case of First Bank of Nigeria PLC and Excel Plastic Industry Limited, as cited. The court was ought to hold that the second to fourth defendants are properly joined as parties to this case and dismiss the application for lack of merit. The issues for determination formulated by the parties are similar. The two issues submitted by the respondents effectively deals with the issues raised by the applicants in this application. For this reason, I adopt it with modifications. That is, does this court have jurisdiction to entertain this case? 2, are second, third, and fourth applicants Proper parties to this case. Issue 1. Does this court have jurisdiction to entertain this case? Jurisdiction is the lifeblood of any adjudication. Without it, the proceeding is a nullity. See Central Bank of Nigeria and Stallion Nigeria Limited, citation supplied. This court is a creation of statute, the National Industrial Court Act, 2006, and the Constitution of the Federal Republic of Nigeria, Third Alteration Act, 2010, hereinafter referred to as the 1999 Constitution as amended, which also delimits its jurisdiction. Section 7, subsection 1, paragraph A of the National Industrial Court Act, 2006, confers exclusive jurisdiction on the court in civil causes and matters relating to labor, while Section 254C, subsection 1, paragraph K of the 1999 Constitution as amended, confers exclusive jurisdiction on the court in civil causes and matters relating to or connected with disputes arising from payment or non-payment of salaries, wages, pensions, gratuities, allowances, benefits, and any other entitlement of any employee, worker, political or public office holder, judicial officer, or any civil or public servant in any part of the Federation and matters incidental thereto. It is settled law that the claim of the claimant determines the jurisdiction of the court, and to determine whether it has jurisdiction, the court will have recourse to facts pleaded in the statement of facts, as well as the claims endorsed on the complaint. CBCE Consulting Engineers and another, and NNPC 2019-14 Nigeria Weekly Law Report, page 1691, page 136, particularly at page 161, and Central Bank of Nigeria and Stallion Nigeria Limited, Supra. The principal claims are set out in the general form of complaint are for an order of the Honorable Court mandating and compelling the defendants to pay the claimants forthwith the sum of 39,671,969 naira, being the outstanding gratuities of the claimants, and an order of the Honorable Court mandating and compelling the defendants to pay to the claimants forthwith the sum of 1,806,363 naira, being the outstanding cooperative dues of the claimants being owed by the defendants to the claimants. The facts in support of these claims are clearly set out in the accompanying statement of facts, particularly paragraphs 5 to 16. Clearly, the issues raised in the statement of facts are within the competence of this court to entertain pursuant to Section 254C, subsection 1, paragraph K of the 1999 Constitution as amended. Whether the claimants will succeed in their claims is not material at this stage of the proceeding. Accordingly, the answer to issue 1 is in the affirmative. Issue 2 are second, third, and fourth applicants, proper parties to this case. The applicant's submission in respect of this case is twofold: non-disclosure of a reasonable cause of action and abuse of court process. They contend that the pleading has not disclosed any wrongdoing against the second to the fourth applicants to warrant the agenda, and that the third applicant is not a director or shareholder of the first applicant. Let me say straight away that the mere assertion alone will not suffice to prove that the third applicant is not a director or shareholder of the first applicant. See Oilfield Supply Center Limited and Johnson, 1987, Law Pavilion Electronic Law Reports, 2365 Supreme Court at page 35. The applicants must do more and show by documentary evidence that he is neither a director or shareholder of the first applicant. The settled principle of evidence is that a burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence. See Section 136, subsection 1 of the Evidence Act 2011. What constitutes a cause of action or reasonable cause of action has been judicially defined in the plethora of cases. Suffice it to say that a cause of action comprises every fact which is material to be proved to enable the claimant to succeed. It is a factual situation, the existence of which entitles the claimant to obtain from the court a remedy against the defendant. It is also the entire set of circumstances giving rise to an enforceable claim. It is the reason for the grievance and complaint to the court for redress. See Thomas and others, and Olufo Soye, Ibrahim and Oshin, and CIL Risk and Asset Management Limited, and Ekiti State Government and others. Citation supplied. A reasonable cause of action is thus a cause of action with some chance of success when only the allegations of the claimants are considered. Insofar as the statement of fact discloses some cause of action or raise some questions fit to be decided by the court, the mere fact that the case is weak or not likely to succeed is not a ground for striking it out. See the cases of Thomas and Olufo Soye, CIL Asset Risk and Asset Management Limited, and Ekiti State Government and others at pages 247 to 248, and Adeshola and another, and Falade Fatila and others. Citation supplied. It is settled law that in determining whether a suit discloses a reasonable cause of action, the processes to consider are the claimant's processes. That is, the complaint, statement of facts, and supporting documents. See Attorney General of Anambra State and Attorney General of the Federation. Citation supplied. For the purpose of this application, the defendants are deemed to have admitted the statements. Let me take that again. Hello?
Hello, sir.
Yes, my lord.
Hello?
We can hear me, Lord. Yes, my lord.
For the purpose of this application, the defendants are deemed to have admitted the facts averred in the statement of facts. Applying this principle to this case, can it be said that the statement of facts does not disclose, does not raise some questions fit to be decided by this court? I do not think so. A review of some paragraphs of the statement of facts, particularly paragraphs 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, and 16, will show that the statement of facts raises a substantial question which this court ought to look into. It is indisputable that there was an employer and employee relationship between the claimants and the first defendant. It is equally evident from paragraphs 2, 3, and 4 of the statement of facts that the second, third, and fourth defendants are the operating mind of the first defendant. In paragraph 14 of the statement of facts, the claimants aver that the second, third, and fourth defendants sold some of the assets of the first defendant and moved orders to other companies managed by them and failed to pay the outstanding entitlements as stated in their letters of disengagement. These are facts, in my view, which this court should look into and which, if proved, could give rise to a remedy against the defendants. It is immaterial, contrary to the submission of the defendants, that the employment relationship has ceased. An employment dispute leaves the determination of the employment, subject, of course, to the law on limitation of actions. So the fact that the claimants are no longer employees of the first defendant is not a bar to this suit. I therefore hold that this suit discloses a reasonable cause of action against the defendants. In the words of Oguntade JCA, as he then was in Henry Stevens Engineering Company Limited and S.A. Yakubu Nigeria Limited, 2002 Law Pavilion Electronic Law Reports, 1020 10204 Court of Appeal at pages 18 to 19. Our judicial system will never permit a claimant to be driven from the judgment seat without any court having considered his right to be heard, except in cases where the cause of action is obviously and incontestably bad. The learned jurist posited that the jurisdiction to peremptorily strike out a case on the ground that the claimant's statement of claim discloses no cause of action must be cautiously and slowly exercised. As he has the potential of denying a claimant the right to be heard, I completely agree.
Sorry, my lord.
I'm sorry, please. The next question is whether the second, third, and fourth defendants are proper or necessary parties to this suit. A good starting point is Order 13, Rule 4 of the rules of this court, which provides inter alia, and I quote, a person may be joined as defendant against whom the right to any relief is alleged to exist, whether jointly, severally, or in the alternative, end of quote. To determine whether a party is a proper defendant in an action, the court will have to examine the claims before it. I have carefully read the originating processes, and in paragraph 5, 6, 7, 8, and 14 of the statement of facts, the claimants made weighty allegations against the second, third, and fourth defendants, which form the substance of their claims against the defendants. In furtherance of these allegations, the defendants filed a statement of defense dated 26 November 2020, and in paragraph 1 of the statement of defense, admitted paragraphs 4, 5, 7, 8, 9, 10, 12, 13, 14, 15, 16, 17, 18, and 19 of the statement of facts. Having admitted these paragraphs, particularly paragraph 14 of the statement of facts, the success or otherwise of the action is not material at this point. Further, the fact that the second, third, and fourth defendants acted as agents of the first defendant does not ipso facto exempt them from personal liability in the peculiar circumstances. Section 90, subsection 1 of the Companies and Allied Matters Act 2020 provides inter alia, and I quote, except as provided in section 89 of this act. Hello?
Hello,
Hello?
Yes, Milord, we can hear Milord.
Okay. Section 90, subsection 1 of the Companies and Allied Matters Act 2020 provides inter alia, and I quote, except as provided in section 89 of this act, the acts of any officer or agent of a company shall not. In the case of Niger Investment and Commercial Enterprises Limited and others, and Alliance International Nigeria Limited and another, cited the respondents. Can you hear me, please?
Yes, we can hear
Can you
Milord.
hear me, please?
Yes,
Okay.
Milord, we can hear Milord.
Okay, because I'm using my phone, so that's why there's disruption. Why for JCA, as he then was, it approved the striking off of the names of the second, third, and fourth defendants. In that case, on the legalistic claim that they were mere agents of the first defendant company. By Order 13, Rule 4 of the rules of this court, a claimant may join any person as defendant against whom the right to any relief is alleged to exist, whether jointly, severally, or in the alternative. The key word there is alleged to exist. Whether this right exists in fact or not is a question of evidence. The claimants allege that the second, third, and fourth defendants sold some of the assets of the first defendant and moved the remaining assets to other companies run by them and refused to pay the admitted entitlements. This fact was admitted in paragraph 1 of the joint statement of defense. In the works of Oguntade JC as it then was, in Niger Investment and Commercial Enterprises Limited and others, and Alliance International Nigeria Limited and another, Supra at page 62. When a court is called upon to exercise its discretion in striking out the names of defendants in a case, the court must refuse to do so unless it has before it ascertained undisputed and conclusive evidence that such defendants are not necessary parties in the action. There is no other way this court will reach this conclusion at this stage of the proceedings. From the averments in the statement of facts, it is clear that the second, third, and fourth defendants are intimately connected with the facts of this case, that in my respective view, their presence will be necessary for a just determination of this truth. It is also the law that a defendant needs not be interested in all the release prayed for or as to every cause of action included in the proceeding. See Order 13, Rule 6, Sub-Rule 1 of the rules of this court. Finally, on whether there is an abuse of court process, I have reviewed the originating process, and in my firm view, a case of abuse of court process has not been made out. In Saraki and another, and Kotoye, citation supplied, Karibi YJSC of blessed memory, held that the abuse lies in the multiplicity and manner of the exercise of the right, rather than the exercise of the right per se. The abuse consists in the intention, purpose, and aim of the person exercising the right to harass, irritate, and annoy the adversary, and interfere with the administration of justice. Can it be said that this action is intended to harass, irritate, or annoy the defendants, particularly the second, third, and fourth defendants? Does this action in any way interfere with the administration of justice? Does this restrict the defendant's fundamental rights in any way? The answer to these questions is a resounding no. In the circumstance, I hold that this action does not constitute an abuse of court process. In the light of the foregoing, I find no merit in this application, and it is hereby dismissed with 50,000 naira cost against the defendants in favor of the claimants payable within 7 days from today. Ruling is entered accordingly. Hello?
As the court pleases. My Lord, yes, we are most very grateful, my Lord, for the well-considered ruling. And we continue to wish, my Lord, more of God's wisdom and knowledge. We are so grateful, my Lord.
That's Mr. Adewale.
Yes, my Lord. May we respectfully, my Lord, in the circumstances, humbly request for a date for trial, my Lord.
Who is asking for a date for trial?
My Lord, is the claimant's counsel, Mr. Timothy Adewale, my Lord.
Is Mr. Rahim present?
My Lord, I'm here.
Okay.
I wanted my learned friend to finish before I could say anything.
Okay, Mr. Rahim, you had him. What date?
Well, subject to the convenience of the court.
Yes.
Subject to the convenience of the court.
Can you come back on 5th of June for trial?
July.
Sorry, 5th of July for trial. Monday, 5th of July for trial.
My Lord, may I respectfully, hold on, sir. May I respectfully ask for a date other than Monday? Because that will be coming from a place and I don't want to be stuck in traffic. Monday from my side is terrible, sir. That July is just, I don't know whether we can come on the Tuesday if it's convenient to the court, sir. Or must it be a Monday, sir?
Well, I'm of the view that you take that 5th. If you are coming from the mainland, I have a trial already for that date. If you come here by 10 or 11, you will still meet the court in section.
As the court
Because if you miss that date, you might not get any other dates this year.
As court pleases, we'll take the 5th date, my Lord.
Well, we'll look at the 5th of July.
As court pleases,
we'll quickly inform the defendants too, because we're not able to reach them before now.
Okay.
But I do not know whether it is for the claimants to open their case.
The way my court operates, we take trial of the claim and the defense on the same day.
It's very okay by us, sir, my Lord.
My Lord, sir, because it's a company and then
is the company not in Lagos?
No, sir. The company is no longer existing, sir. That's what I wanted to say. I needed to speak with the chairman.
Still available.
For example, now, sir, as I speak, my Lord, sir, the chairman of the company, sir, as we speak.
Who is your witness? Who is your witness?
Well, is the second defendant.
Is the one defendant is your witness? Hold
I
on.
would, yes, my lord, I would discuss with.
Hold on, please.
Let me quickly check. Yeah, where is this thing?
Yes, your witness is Mr. Shehu Obagun. Is he not present? Today is just the 10th of June. The matter is being adjourned to the 5th of July.
As a call, please, my lord.
So, Rahim, do I record that it is convenient for you? Mr. Rahim. Hello, Learned Counsel for the defendant.
Mr. Rahim is there. It's not Mr. Rahim. He's still there, my lord.
I need his response so I know what to record for him. Mr. Rahim. Mr. Rahim.
Hello, sir. I am here.
Yes.
I am here, sir.
That the date is convenient for you?
Yes, my lord, sir. For trial. May I also state on record, sir?
Yes. Yes, go on. Hello. Hello.
That,
hello, Mr. Rahim.
Wow, the matter passed with my learned friend. Very, very well. Hello.
Yes.
Yes, I can hear you.
Yes.
It's clear
So
from
may I
here,
state
my
on
lord.
record? I need to hear you.
Yes, my lord. I state on record that before, while this matter was going on, sir, counsel for the claimant and I, as well as me, he has been discussing with his client, has also been discussing with our clients too, looking at the possible amicable resolution of the matter. I told you we have even exchanged some ideas on how to go about it, sir. So I do not know whether it will be appropriate to report for to be for a report of settlement and trial.
Go ahead with your settlement. If you settle before that date, you file terms of settlement.
Okay, sir.
Otherwise, you go to.
I don't want it to be on record, so it will seem as if I'm not bringing
I have
it
put it on record.
court.
I've recorded
As
it.
accomplices. As
As
accomplices.
good life, sir.
As accomplices.
This case is adjourned to Monday, 5th of July, 2021 for trial of the claim and the defense in Lagos.
As accomplices. We are very much grateful, my lord. We thank my lord very much.
Thank you. I appreciate you.
Thank you, my lord, for the ruling.
Thank you. Have a wonderful day.
And the indulgence.
Thank you, my lord.
Thank you.
I suppose that will be the end of the proceedings, sir.
Yes, that's the end of the. We will now take the next case.
Okay, sir. So we may take our leave, sir.
Yeah, so you can exit.
Thank you very much, sir.
Thank you.
Mr. Adewale.
Thank you.
Thank you.
Recording in progress. Recording in
Counsel for Turkish Airlines, are they present?
Yes, my lord.
Hold on. Yes, appearances, please.
Respectfully, my Lord, O Ogunrinde, together with O
Hold on.
Okukuni.
Slowly,
Yes, my
please.
Lord.
Slowly, please. Are the parties present apart from their counsel?
Turkish Airlines is not represented by any official.
Okay. What of the defendants? Okay, please announce your appearance.
Yes, my Lord. O Ogunrinde.
Yes.
With O Okuguni for the claimant applicant.
Spell the surname for me.
OKU.
Yes, OKU.
GUNI.
OKUDUNI. Is that correct?
That's correct, my Lord.
Okay, for the claimant.
Yes, my
applicant.
Lord.
Any appearance for the defendant? Any counsel for the defendant? Well, this ruling should have been delivered on 20th April 2021, but for the strike by the Judiciary Staff Union of Nigeria, it was slated for today because of the uncertainty of our resumption. But thankfully, yesterday, we got notice that the strike has been called off, but we could not stop today's proceedings because the hearing notices has gone out. So I hope that that is accepted by parties. I'll proceed to now deliver the ruling. By motion on notice, dated and filed on, hello, are we together?
Yes, my
Is
Lord.
Ogurinde? Okay.
Yes, my Lord.
Okay. By motion on notice dated and filed on 2nd November 2020, brought pursuant to Section 16 of the National Industrial Court Act 2006, Order 22, Rule 1 of the National Industrial Court of Nigeria Civil Procedural Rules 2017, the rules, and under the inherent jurisdiction of this honorable court, the claimant applicant prayed the court for an order of interlocutory injunction restraining the defendant respondent, acting by its trustees or through any of its members, agents, privies, proxies, affiliates, or any person or entity whatsoever from picketing and or disrupting the business of the applicant, including but not limited to the operation of passenger and cargo flights, operations at check-in counter, embarkation and disembarkation of passengers and baggage, and the unloading and offloading of these passengers and cargo freighter freights, pending the hearing and determination of this suit. 2, an order of interlocutory injunction directing the respondent to immediately stop, withdraw, and desist from further interference with the business of the applicant pending the determination of the suit. 3, an order of this honorable court restraining the respondent from compelling, cajoling, persuading, or coercing members of other unions or third parties to take any steps aimed at interfering with the business of the applicant pending the hearing and determination of this suit. Another of interlocutory injunction restraining the respondent from enforcing or trying to enforce any of the threats contained in the defendant's letter of 5th May 2020 against the applicant. Another of this honorable court mandating the Nigerian police force to provide its professional services in order to ensure the respondent's due compliance with the orders of this honorable court. And for such further or other orders, this honorable court may be free to move in the circumstances. Upon the following grounds, the applicant has approached this court via its originating processes dated and filed 2nd November 2020 to litigate on its grievances with the defendant respondent. While this matter is pending and awaiting determination by this honorable court, the respondent has continued to interrupt the applicant's operations under the guise of conducting a picket. Particularly, the respondent obstructed the applicant's cargo shipment arriving into Nigeria and unlawfully prevented the applicant from offloading cargos at the airport. The respondent also prevented the applicant's passengers being checked in to board the applicant's aircraft, a conduct which is vexatious, highly reprehensible, and distressful to the applicant. This conduct of the respondents has been seriously interfering. I think it should be the conduct of the respondent. The conduct of the respondent has been seriously interfering with and preventing the applicant from carrying on his business operations peacefully and as scheduled and performing his obligations to his passengers under their contract of carriage. Fourthly, having regard to the respondent's antecedents, namely intercepting the applicant's cargo and preventing the applicant from unloading and offloading his goods at the Murtala Mohammed International Airport, Lagos, Nigeria, obstructing the check-in of passengers scheduled to board the applicant's aircraft, thereby causing a long delay in the departure of the applicant's aircraft from Lagos, Nigeria, and threatening the management of the applicant in relation to the conduct of his business in Nigeria. There is a very high possibility that the respondent will not refrain from this dastardly act unless the respondent is restrained by an order of this honorable court. The respondent's conduct prejudices this pending suit as he seeks to frustrate, embarrass, and arbitrarily compel the applicant into meeting his unlawful demands for a statement of employees that were lawfully disengaged by the applicant. The application is supported with 59 paragraphs affidavit, deposed by Mr. Olaniyi Makeu, the Sales and Operations Officer of the applicant. Attached to the affidavit are 20 exhibits marked as Exhibit TK01 to TK20. These are respondents' letter to applicant dated 4th July 2019, requesting for a meeting on 17 July 2019, respondents' letter dated 18 November 2019, caption request for meeting, final notification. Applicant solicitor's reply to the letter dated 5th December 2019, respondent's letter dated 14 January 2020, intimating applicant of names of his staff who have elected to join the respondent and requesting deduction of monthly checkup dues. Respondent's letter dated 2020, protesting victimization of its members by the applicant. Applicant solicitor's response dated 25th February 2020, denying the allegations. Applicant solicitor's petition to the Inspector General of Police against the respondent dated 10th March 2020. Respondent's letter dated 25th May 2020 to applicant's chairman, protesting termination of employment of some of its members. Applicant's letter to Honorable Minister of Aviation dated 15th October 2020. Pictures, electronic mail communication between applicant's regional station manager and his solicitors dated 31st October 2020, complaining of some social media posts. Electronic mail communication between applicant's regional station manager and his solicitors dated 31st October 2020, informing them of a passenger who was denied boarding. Copies of Vanguard online newspaper of 1st November 2020 on the effect of respondent's strike. Exhibits TK02, TK03, TK10, TK11, TK13, TK14, and TK20 were not attached. In compliance with the rules, the applicant filed a written address dated 2nd November 2020. The applicant filed a further affidavit dated 4th November 2020, sworn to by Obianuju Okugoni, legal practitioner in the firm of Aluko and Oyebode, solicitors for the applicant. And attached to the further affidavit are exhibits TK20, financial statement of the applicant as at June 2020, TK21, applicant stock market chart, TK22, letters of termination of employment of Olurotimi Moses Adelakun, Fumilayo Ramat Ogunsawo, Ilogosa Ajowogan, and Florence Ngozi Naomi Chukwu Nwora, dated 22nd May 2020. TK23, applicants letter dated 22nd May 2020 to Honorable Minister of Labor and Employment, captioned Notice of Redundancy. TK24, respondents notice of withdrawal of services dated 5th August 2020. And TK25, applicant response to notice, respondents notice of withdrawal of services. In opposition to the application, the respondent filed 56 paragraphs counter affidavit dated 22nd December 2020, sworn to by Comrade Ibrahim Aliyu, his organizing secretary. And attached to the counter affidavit are 6 exhibits, marked exhibits N1 to N6. These are respondents' letter dated 14 January 2020 to applicant, introducing applicant's branch executives and requesting for meeting. Respondents' letter dated 20th February 2020 to Honorable Minister of Labor and Productivity against the applicant. Respondents' letter dated 20th February 2020 to applicant's executive vice chairman, African Sub-Sahara. Respondents' letter dated 20th February 2020 to applicant's general manager. Respondents' letter dated 25th February 2020 to the Commissioner of Police, Airport Command, and respondents' letter dated 3rd March 2020 to applicant's president. Also attached to the counter affidavit is a written address dated 11 December 2020. In response to the counter affidavit, the applicant filed 18 paragraphs further affidavit dated 23rd February 2021, deposited by Ogeneyome, Odioro legal practitioner, and Aluko and Oyebode, solicitors to the applicant, and a reply address. Arguing the application on 24th February 2021, Mark Moore, the Esquire, relied on the affidavit in support, the 2 further affidavits and attached exhibits, and adopted the written address and reply address. By way of adumbration, Learned Counsel urged the court to consider the following issues: whether the respondent can, while mediation proceedings are pending before the Ministry of Labor and Productivity, deploy self-help mechanism to disrupt applicants' business. Refer to paragraphs 30 to 32 of the affidavit in support and exhibit TK14. Whether in fact and in law, the respondent has disrupted applicants' business. Reliance was placed on exhibits TK5, TK13, and TK19. Whether the respondent can unlawfully disrupt applicants' business in violation of Section 4, Subsection 1, and Section 6, Subsection 1 of the Trade Disputes Act. And lastly, whether paralyzing applicants' business amounts to picketing. He answered the questions in the negative and submitted that he pays everybody, that the applicant continues to fly. The balance of convenience is in favor of everybody. He submitted that the argument of respondents' counsel that the applicant lacks the legal right to sue because it refused to recognize the respondent as a union and terminated some staff for union activities. Sorry, let me take that again. He submitted that the argument of respondents' counsel that the applicant lacks the legal right to sue because it refused to recognize the respondent as a union and terminated some staff for union activities. I think there is an error there. I take it for the last time. He submitted that the argument of the Respondents' Council is that the applicant lacks the legal right to sue because it refused to recognize the respondent as a union and terminated some staff for union activities. The court was urged to grant the relief sought. Gerald Nweneka Esquire, learned counsel for the respondent, relied on the counter affidavit, attached exhibits, and adopted the written address. He noted that the applicant's further affidavit, dated 23rd February 2021, and reply on point of law was filed out of time and served on him in court that morning and cannot be used. The court was urged to discountenance it. He submits that picketing is a well-known trade union activity, and the respondent is within his rights as the applicant has refused to adhere to resolutions by relevant bodies at the airport, noting that the grant of the interlocutory injunction will portend dangers to the unions and their members. The applicant has not done equity and not entitled to equity. He explained that the mediation was taken over by the Ministry of Aviation and nothing has happened on it. The respondent has not disobeyed the order of the court and urged the court to refuse the application. Mark Moore, Esquire, in his reply to Learned Counsel's submission, explained that time began to run today and apologized for serving the further affidavit and reply address directly on the respondent. A summary of the facts justifying this application is that the respondent attempted to unionize applicants' employees. In furtherance of this, it wrote a letter dated 4th July 2019, informing the applicant that its employees have elected to join the union and requested for a meeting to formalize the relationship. The applicant did not respond to the letter, necessitating further correspondence, which were also not replied. Peeved, the respondent in his letter of 18th November 2019 wrote inter alia, and I quote, "We are compelled by the circumstance of your unacceptable defiance of the law to put your management on notice that should you maintain your present stance on the matter, we shall be moved after 7 days from hence to embark on any lawful activity, any lawful action we deem fit in order to obtain an amelioration," end of quote. This threat was executed on 4th December 2019, resulting in a disruption of applicants' business. This fact was communicated to the respondent in applicant solicitor's letter of 5th December 2019, wherein they also wrote that applicants' employees are not members of the respondent. By letter dated 14 January 2020, the respondent forwarded a list of applicant staff who has signified the intention to join the respondent with a request to deduct the checkup dues. Parties eventually met on 4th February 2021. No, 2020. I beg your pardon, please. Parties eventually met on 4th February 2020. But by its letter of 20th February 2020, the respondent protested the applicant's alleged harassment of some of his employees on account of their union membership, which allegation the applicant denies. Hello? Hello? Hello?
Yes, my lord.
Okay, I need to be sure that parties are still on.
My lord, we're here and our videos are on, my lord.
Okay, thank you. The applicant further states that despite exchange of correspondence between the parties, the respondent continues to disrupt his operations. Following termination of some of his employees, including members of applicant's branch executive council, by letter dated 25th May 2020, the respondent threatened to totally paralyze applicant's operation if his demands were not met. On 7 June 2020, respondent intercepted applicant's cargo freighter, and on 29th October 2020, disrupted his flight schedule. The applicant fears that unless restrained, the respondent will not desist from his arbitrary action. The respondent denied carrying out any unlawful activity but picketed the applicant on 4 December 2019. It also states that the applicant did not honor the resolutions reached on 4 February 2020. And shortly after the meeting began to threaten its members to denounce their membership of the union or risk losing their jobs, resulting in their letter of 20th February 2020 to the Honorable Minister of Labor and Employment, an applicant and the applicant. But on 22nd May 2020, the applicant made good his threat and terminated the employment of 4 of his employees who were executive members and refused to denounce their union membership. The applicant submitted one issue for determination in the written address in support of the application, to wit, whether the applicant is entitled to the grant of the injunctive relief sought on the motion on notice in the light of the peculiar circumstances of this case. Relying on Section 16, National Industrial Court Act 2006, the applicant argued that the court is properly vested with jurisdiction to grant the order sought, pending determination of the substantive suit. He submitted that interlocutory injunction is granted to protect an applicant against an irreversible injury resulting from a violation of his rights, for which damages will not be an adequate compensation, on the authority of Adefarati and Governor of Ondo State as cited, noting that the respondent's conduct greatly interfered with his right to carry on his daily operations without fear of embarrassment and undue interference with his business. It also submits that it has fulfilled the preconditions for the grant of the application, which include the existence of a legal right to be protected, real risk of imminent danger, balance of confidence is in his favor, damages would not be an adequate compensation, and is undertaking to pay damages if it is shown that the injunction ought not to have been granted. Elaborating on these conditions, the applicant explained that it has the right to operate his business from Murtala Mohammed International Airport and operates his business from the airport, and is not averse to the existence of a working relationship with the respondent. But the respondent has made several attempts to disrupt his operations. He further submits that there is no justifiable basis for a respondent to obstruct his flights based on retrenchment of some of his staff, because it has the right to hire and fire his staff, provided it complies with the agreed procedure for doing so. Applicant contends that the respondent's action did not comply with the dispute resolution mechanism of the Trade Dispute Act, particularly sections 4, subsection 1, and section 6, subsection 1 of the Act. It admits that the respondent activated the dispute resolution mechanism by writing to the Minister of Labor, which led to the intervention of the Minister of Aviation and subsequent mediation on 18 September 2020, in spite of which the respondent continues to obstruct the peaceful operation of his business. Applicant also contends that the respondent's action does not constitute picketing within the purview of section 43(1) of the Trade Unions Act, and so it is entitled to the protection of the law. Applicant argues that refusal of the application will result in irreparable inconvenience and harm to which it cannot be remedied in damages. It submits that in determining where the balance of convenience is, regard must be had to whether it can be compensated by damages on the authority of Oji and Zaria Industry Limited, as cited, and explained that the balance of convenience is in its favor because it has not engaged in any act that has caused discomfort to the respondent. The respondent also canvassed one issue for determination, which is whether the applicant has presented to this honorable court an existing legal right to be protected by this honorable court based on the facts of the respondent's counter affidavit. Relying on Akapo and Hakim Habib, as cited, the respondent argued that there is no power to grant an injunction if the applicant has no legal right recognizable by the court, noting that the applicant violated section 25 of the Trade Unions Act and section 96 of the Labor Act by refusing to recognize the union and terminating the employment of its staff for refusal to denounce their membership of the respondent, and thus has no legal right to be protected by injunction. It further submits that it exercises its legal rights as enshrined in Section 43 of the Trade Unions Act by picketing the applicant, and grant of the injunction will amount to unwholesome disregard of the law. Lastly, it was submitted that injunction by its nature is an equitable remedy, and he who comes to equity must turn with clean hands and do equity. And the applicant, after violating the law, alleged that it violently and forcefully engaged in disruptive actions at the airport with a view to misleading the court, noting that it will suffer if the application is granted. By way of reply on points of law, the applicant submits that Section 25 of the Trade Unions Act and Section 9, subsection 6 of the Labor Act do not support the submission of the respondent, in that it does not justify the respondent's unlawful obstruction and interference with his business. Referring to AG of Lagos State and AG of the Federation, as cited, it submits that his legal right to conduct his business was clearly infringed as his operations were unlawfully obstructed by the respondent on more than 2 occasions. Relying on Agueli and Sufi, it contends that it has not done any wrong under the law and a road is to seek protection of the court. The issue for determination formulated by the applicant adequately addresses the question before this court, and I adopt it with a slight modification. That is, whether the applicant is entitled to the grant of this application in the circumstances of this case. An application for interlocutory injunction calls for the exercise of the discretion of the court, which in all cases must be exercised judicially and judiciously in accordance with settled rules and principles. It is the law that an interlocutory injunction is granted to protect an applicant against injury resulting from a violation of his rights, which cannot be adequately compensated in damages if the case is resolved in his favor. Siabo Sade Laboratories PLC and Union Merchant Bank Limited and another. The burden of proof is on the applicant. The factors which the court will consider in determining whether to grant or refuse an application for interlocutory injunction are commonplace and have been ably argued by the applicant. These are the existence of a legal right to be protected by the injunction, that there is a serious issue to be tried in the case, the balance of convenience, damages will not adequately compensate for his loss if he succeeds at the end of the case, the conduct of the parties, and satisfactory undertaking as to damages. Say Alhaji Gidado Ba and Adamawa Emirate Council and others. Braithwaite and Standard Chartered Bank Nigeria Limited. And lastly, Adeleke and Lawal. Citation for these authorities are supplied. The overriding consideration in application for an interlocutory injunction is whether it is just or convenient to make the order in the circumstances of the case. See Section 16(1) of the National Industrial Court Act. At the end of the day, the decision to grant or refuse the application for interlocutory injunction will depend on the facts and surrounding circumstances of the case. See La Ferry Nigeria Limited and another, and now Merchant Bank PLC and others. 2001, 35 weekly reports of Nigeria, 106 at 117 to 120. The undisputed facts show that the initial failure of the applicant to accord recognition to the respondent in his establishment gave rise to respondent's industrial action of 4 December 2019, resulting in a disruption of his business. Although parties eventually met on 4 February 2020, the respondent alleged that the applicant did not honor the resolutions reached at the meeting and threatened its members with termination if they did not denounce their membership of the union. which alleged threat was carried out on 22nd May 2020 with the sack of 4 of respondents' executive members. Applicant denies this and insists that it acted within the law and his business interest in disengaging the staff. The respondent was not persuaded and carried out further picketing on 7 June 2020 and 29 October 2020, which disrupted applicant's flight schedule. At this stage of the proceedings, I am not allowed to delve into the issues, which will be determined at the trial. The applicant's submissions dwelt largely on issues beyond the scope of this application, and I will refrain from commenting on them. There is no doubt that the applicant has a legal right to carry on his business without fear of embarrassment and undue interference, and there is a serious issue to be tried in this case. The applicant also argues that the balance of convenience is in his favor because it has not engaged in any act which has caused discomfort to the respondent and grave injustice will be done to it if the application is refused, urging the court in considering the balance of convenience to have regard to whether it can be compensated in damages if it succeeds at the trial. Conversely, the respondent contends that the applicant has not shown any cognizable legal right, and his right to conduct his activities must be protected by the court, and the grant of the application will occasion grave miscarriage of justice. Picketing is a major form of industrial pressure directed against an employer and involves occupation of the workplace. Its aim is to persuade an employer to give up resistance to union claims and fellow workers to follow the union's call for a boycott. Inevitably, picketing may interfere with the employer's business and result in economic damage. The law recognizes this possibility, but still allows peaceful picketing. And as long as the picketing is peaceful, it is immaterial that the employer suffers economic loss and attendant losses. See Nigerian Labor Law, 4th edition, by Akintunde Emiola, page 535, and Employment and Labor Law in Nigeria, by Elizabeth A. Oji and Alphonse D. Amucheze, at page 307. Indubitably, the right of the applicant to carry on his business without undue interference is countervailed by the respondent's right to carry on his union activities without any restriction from the applicant. Article 2 of the Freedom of Association and Protection of the Right to Organize Convention, 1948, number 87, provides that workers and employers without distinction whatsoever shall have the right to establish and subject only to the rules of the organization concerned to join organizations of their own choosing without previous authorization. Elaborating on this provision, the Committee on Freedom of Association posits that the right of trade unions to picket should not be subject to interference by public authorities, and prohibition of strike pickets is only justified if it is violent. Consequently, the committee considers that taking part in picketing and firmly but peacefully inciting other workers to keep away from their workplace is not unlawful. This has been codified in section 43(1) of the Trade Unions Act, Cap T14, Laws of the Federation of Nigeria, which provides, and I quote, "It shall be lawful for one or more persons acting on their own behalf or on behalf of a trade union or registered federation of trade unions or of any individual employer or firm in contemplation of furtherance of a trade dispute to attend at or near a house or place where a person resides or works or carries on business or happens to be, if they so attend for the purpose of peacefully obtaining or communicating information or of peacefully persuading any person to work or abstain from working," end of quote. There is nothing before me to show that the respondents' activities have been violent. See paragraphs 10, 11, 24, 25, 26, 33, 34, and 35 of the affidavit in support of the application, and paragraphs 10, 11, 12, 13, 28, 29, 30, 42, 45, and 46 of the counter affidavit. It is well established that the essence of the grant of injunction is to protect the existing legal right of a person from unlawful invasion by another. An application for injunction is won and lost on the basis of existence of competing legal rights. Injunction being an equitable remedy, he who comes to equity must come with clean hands and do equity. Akapo and Hakim, Habib, and others are cited. It has always been a strong ground for grant of an application for interlocutory injunction to show that the conduct of the respondent is unjustified and the surrounding circumstances favor a grant of injunction. Sionyoso and Nebedu and others are cited. The conduct of the applicant, as manifest in their affidavits and attached exhibits, is less than salutary. It resisted the attempt to unionize its employees, thus inducing the respondent's action. It cannot, in my respectful view, complain that the respondent's action is impacting on his business. As observed by the learned authors of employment and labor law in Nigeria, Supra, as long as the picketing is peaceful, it is immaterial that the employer suffers economic thoughts with attendant financial losses. The rest, in this case, is not capable of annihilation. The applicant has not come with clean hands and has not done equity. In the circumstance, it will amount to an improper exercise of discretion to restrain a lawful exercise of the respondent's legal right in the peculiar circumstances of this case. Accordingly, the application for interlocutory injunction is refused, and the motion on notice dated and filed on 2nd November 2020 is hereby dismissed. Owing to the nature of this case, I grant it accelerated hearing. Consequently, this case is fixed for July. This case is fixed for trial for Monday, 5th July 2021. The order of interim injunction made on 10th November 2020 is hereby vacated. I make no order as to cost. Ruling is entered accordingly.
As court pleases, we're grateful, my lord.
Thank you. So the case comes up on 5th of July 2021. Hearing notices will be served on parties.
As court pleases.
Thank you. That is the end of the proceedings.